There you go. Good morning, Mr. Vurimindi.
Good morning.
I think you're muted.
Yeah. I kept it. There's a background noise is there, so I just muted.
Mr. Herbst, this is the court reporter, Julie Davis.
Yes.
I can't see who you represent. Your counsel for defendant who?
Counsel for two defendants, 806 Capital LLC and Leo Addimando.
Okay, can you spell each one?
806 is numbers 806. Capital is CAPITAL, LLC. Leo Addimando is LEOADDIMANDO.
Thank you. Is Mr. Fenningham present?
He was. I think he stepped away.
Can you just tell me who he represents?
I don't remember.
He's for defendant though also, right?
Everyone else will be.
I think he is representing Allison Borowski, Nicholas
Okay.
Palmer, Iliad Hartson.
Thank you. I'll have him tell me all the spellings when he gets on. Thank you.
He's on.
Mr. Fenningham?
Good morning.
Morning. This is the court reporter. I just wanted to get your defendants' names and the spellings of them.
Sure. I represent Allison Borowski. That is BOROWSKI.
That's Allison with
two L's.
Yeah.
I represent also Nicholas Palmer. That's NICHOLAS. And lastly, Elliot Hodgson, which is ELIOTHODGSON.
Thank you, sir. In case you guys need my full name, it's Julie, Julie Davis, DAVIS.
Thank you.
Good morning, everyone.
Good morning.
Good morning. Ms. Falcone, can I please have who you represent for the record and the spelling of their names?
Sure. I represent the defendant Jason, Jason. Last name is Tiefenbach, Tief as in Frank, En as in Nancy, B as in boy, ACK.
Thank you. I'm Julie Davis for the record.
Hi, Julie. Thank you.
Mr. Brownstein?
Doesn't look like Mr. Brownstein.
I'm getting him set up. He'll be here in a minute. Sorry.
Uh-huh.
I don't need to share screen, do I?
Good morning, everyone.
Good morning.
Good morning. Mr. Brownstein, can I please have who you represent and the spelling of their name?
Represent defendant Daniel Siegel, Segal.
Thank you. I'm Julie Davis for the record.
Good morning.
Good morning.
If I have to, yeah. Okay. Yeah, I'm there. Oh, it says I'm mute. You must have muted me. Looks like everybody's muted. Good morning, all. It's 10 a.m. We do have a court reporter, is that correct?
Yes, Your Honor.
All right.
Good morning.
Will the parties identify themselves for the record?
Good morning, Your Honor. Jonathan Herbst for defendants 806 Capital LLC and Leo Addimando.
Can you speak up just a little bit louder or adjust your volume?
Let me try. Jonathan Herbst for defendants 806 Capital LLC and Leo Addimando.
Very well.
Good morning, Your Honor. Tim Fenningham for defendants Allison Borowski, Nicholas Palmer, and Elliot Hodgson.
Good morning, Your Honor. Mark Brownstein for defendant Daniel Siegel.
Morning, Your Honor. Lorianne Falcone, attorney for defendant Jason Tiefenbach.
Good morning, Your Honor. This is plaintiff Vamsidhar Vurimindi.
Before we proceed, I'm still having a little bit of trouble hearing clearly, but it may be my end. Let me see what I can do. All right. I believe that may have addressed the problem. We're here on what are multiple motions. I believe there are 4, in fact, each filed by a defendant or groups of defendants. We'll start with, does anyone have a preference as to how we should address this other than going by the control numbers in the order they were filed?
That seems to make sense, Your Honor.
All right, according to my notes, then it would be last 4 digits, 4598, filed by the defendants 806 Capital LLC and Addimando. Is that pronounced correctly?
Yes, Your Honor.
All right, I'll hear you on your motion.
Your Honor, a plaintiff has filed a lengthy complaint, and the counts against these defendants or counts 26, 27, 28, 29, 30, and 31. I've lost the video, Your Honor. Can you hear me?
I can still hear you.
Counts 26, 27, 28, 29, 30, 31 mention these defendants. Count 26, I'll start with, Your Honor. It's entitled breach of duty. I
May
believe.
I interrupt you to ask this question? You outlined the 6 counts you're proceeding on. Would this then dispose of the entire case vis-a-vis your client, or would there still be counts remaining?
It would be the entire case against my client, Your Honor.
All right, then, go ahead.
Count 26 is entitled breach of duty, Your Honor. And I read that as a breach of contract count. And essentially, the plaintiff contends that the condominium that he bought was defective with elevator and a whole litany of issues. The defense is that he did not sue the seller of the condominium. Attached to the complaint are his exhibits A and B, which show that he purchased his condominium from 313 Arch Partners LP. And that's who he bought it from. That's the developer. My client, 806 Capital and Leo Addimando, was the property manager for the condominium after it was occupied. Now, so it's the defense on that count is very simple, Your Honor. These defendants did not sell this condominium to Mr. Vurimindi. Now, in his answer to the motion, he's attempting to pierce the corporate veil. He didn't plead piercing the corporate veil. He gives no reason for not suing the 313 Arch Partners, which is the exhibit he attached to the complaint. And although Mr. Addimando is involved and was probably a principal in each of those separate entities, that's not any reason for piercing the corporate veil. They are separate legal entities, and they had separate roles in the project. And so that's the defense on that count. If we move on, Your Honor, count 27 is entitled bad faith. And this also, I think it sounds in tort. And the gist of this count is that the defendants, 806 Capital and Leo Addimando, were the managing, the property manager for the condominium. And as a result of Mr. Addimando's activities at the condominium, the property manager was receiving complaints from numerous of the other condominium owners. So Mr. Addimando sent a warning letter, or 806 Capital sent a warning letter to Mr. Vurimindi, saying there's been complaints about you, and just sort of telling him what the bylaws were and so forth. He then responded by asking, well, who's complaining about me? And Mr. Addimando refused to tell him who was complaining about him. That's the gist of what count 27 is about, Your Honor. He does not attach as an exhibit to his complaint the contract that 806 Capital had with the developer or the condominium association for its duties. So the exact duties of the condominium of the property manager are not in evidence. But aside from that, it fails to state a cause of action. There's no law or requirement that in a situation where a property manager says, essentially, Mr. Vurimindi, please abide by the bylaws. There's been complaints. There's no obligation to reveal to him who's complaining about him. So count 27, I submit, fails to state a cause of action. Count 28, Your Honor, is for defamation, and actually count 28 is for defamation. Count 29 is for invasion of privacy. Count 30 is for emotional distress. And as we read those lengthy allegations with those three counts, they all repeat the same averments, and there's general allegations that Mr. Addimando said and did certain things. He denies that he did, and he filed an affidavit with the motion for summary judgment. He did, Mr. And what's important here is Mr. Addimando did send an email to the other property owners saying, in effect, there's been, and it's an exhibit, I believe, in Mr. Vurimindi's answer to the motion, in which he said, if you have issues with Mr. Vurimindi, report them to the police. And if you have problems with Mr. Vurimindi harassing you, notify the police, which in fact did happen. That in and of itself is not defamatory. It's not an invasion of privacy. There's really nothing wrong with what Mr. Addimando did. And what I think is important, Your Honor, for all of these counts, all of these tort counts, is that, in fact, Mr. Addimando was convicted of 2 counts of stalking. And I attached the Superior Court opinion as an exhibit to my motion, which affirms the conviction for stalking. So that, and I also cite in my memorandum of law in section G, Your Honor, the case law, and the main case being a case called Schaefer, SHAFFER versus Smith, 543 Pennsylvania 526, which states that the conviction of a criminal conviction is he's collaterally stopped from denying the fact of his conviction, those facts. So he was in fact harassing people. He can't deny that. It's been affirmed on appeal by the Supreme Court, and unless that's ever overturned in the future, he is essentially stuck with that criminal conviction, and that applies to all of these counts. So I think the collateral estoppel issue is important for all of these counts. And aside from that, Your Honor, other than the one or two emails that Mr. Addimando sent saying, let's, report it to the police or keep a record of what Mr. Vurimindi is doing, which is not actionable. He didn't do anything else. There's allegations that Mr. Vurimindi was being followed and so forth. Well, Mr. Addimando didn't do anything, didn't do any of that, and Mr. Vurimindi has no evidence that he did. So to summarize, Your Honor, it's a pretty long complaint with a lot of allegations, but none of them can be proved by Mr. Vurimindi. There's also a civil conspiracy count. That's the count 31 for civil conspiracy, and I have this in my memorandum of law. There has to be evidence that the individuals did something unlawfully or did a lawful act by unlawful means, and those elements of civil conspiracy just do not exist in this case. So I think I've summarized a lot of factual allegations, Your Honor, but and I've just tried to cut to the chase on it. Thank you.
Very well. Plaintiff, your response?
Good morning, Your Honor. The reason that 806 Capital Leonard's Addimando was sued for breach of contract is Leonard's Addimando, as the managing partner of the 806 Capital LLC, that's a tent organization. Among the tent organization, he developed multiple properties, and then he communicated with me.
Sorry, I'm having trouble. Sir, can you repeat that sentence? I'm having trouble understanding.
And Leonard's Addimando communicated with me using 806 Capital LLC email, and with that email saying Leonard's Addimando, managing partner, 806 LLC. Since beginning, that's the only one email we have been corresponding with him, whether they're negotiating the sale prices, negotiating the terms of the contract, negotiating what items should be there inside the condo. All these terms has been negotiated through only that email. And then all his employees using the same email, 806capital.com email, and everybody is there. Addimando accepted that there is employees, and then they communicated using that email, and then they made those promises in whatever those emails were there. And when we signed the sale agreement, then he brought up a 313 Arch Partners is a wholly 100% subsidiary of this 806 Capital LLC. And he's made a sale agreement with that. And
Say that again. I'm sorry, say that again. He made it what?
Sale agreement through a 100% subsidiary called 313 Arch Partners. And after the purchase of that condo, during the purchase of the condo, while we are closing we have disagreements with the closing, at the time, he himself, as a managing partner of the 806 Capital LLC, he intervened, and then he made a lot of correspondence with me through that email. And then he himself even picked up the closing agent and then the title search agents.
Sorry, say that again, sir.
Title search agents. Entire transaction is being done through the 806 Capital LLC, except the name is 313 Arch Partners. And then after the sale transaction, when we have problems with the condo, all communications were occurred again through the 806 Capital LLC, email, and then telephone number, and then the employees. All of them are 806 Capital LLC employees. They will come to inspection to my condo when I have problems. They come and then take notes of it, and then they promised me to complete those problems. The whole the transaction, everything is involved with 806 Capital LLC except the name of the company. Who signed is 313 Arch Partners, and then still signed by the Leonard's Addimando. And then now the important point is the 313 Arch Partners does not exist anymore. There is no property, there is no assets or anything. And then the company has been defunct. And 806 Capital LLC is reincarnated as altriaproperties.com. And then now he has some others under the tent. He has some other subsidiaries. He's doing some other activities. But for all practical purposes, the 806 Capital LLC is a tent organization, and then the employees are all, they are all working on all these subsidiary companies. If one property has one LLC, other property has one LLC, everybody is working at the same office, and then there is no distinction that we can, as a buyer, oh, it is coming from 313 Arch Partners, but because 806 Capital LLC is the promoter and developer, and they advertise through the website what condos he's developing. So they made
you plaintiff. I understand what you're saying. My question has to do, at least with the count 26. What was the duty this entity owed you, and where was the breach?
They have not disclosed the defects, existing defects in the condominium of all the useful life of the structural elements like a roof, elevator, and brick walls, and then sewerage pumps. Those are all the ones they have not disclosed it during the negotiation or after the negotiation. And the problem arises is 1.5 years after the closing the transaction, one day the roof got collapsed about my condo. Water got damaged, come into my condo, and then all my contents were destroyed. And then I have to relocate to somewhere else, and then I have to repair. I have to bear those relocation expenses, and then I have to.
What was their duty to you? You're telling me what resulted, but my question is, what was the duty?
Leonard's Addimando and 806 Capital LLC made an agreement with me that they are going to give me what I'm negotiating. They're selling a property that is completely disclosing all the defects and then telling me that what I am purchasing. That's the duty they have, is to disclose every known defect and then the material defects affecting the condo, and then including their relationship with the 313 Arch Partners. Also, they have not.
Sorry, say that again, sir. Sir, say that again. Including what?
Including their relationship with the 313 Arch Partners. We, not only me, that everybody who purchased that condos at the condominium, we are all know only 806 Capital and Leonard's Addimando. Otherwise,
plaintiff, I'm going to move to count 27. That's where you allege bad faith.
Yes. After the condominium roof got collapsed and then water leaked into my condo, and then he still, 806 Capital LLC, he's running, he, in the capacity of 806 Capital LLC, he, as a developer, he maintained the controlling votes of the condominium association. So he never relinquished his condominium, his power over the condominium association. He still sits as a executive member of the condominium association. And then he's still as a developer. And also there is one more entity is involved, 806 Properties LLC. And also through that organization, he collects the maintenance and then he maintains
Say
the
that
property.
again, sir. Sir, you need to slow down and say that again, please.
He collects the maintenance and then maintains the property. So there is no way that we can distinguish between what role he's playing and what capacity he's playing, all being done by the one person. And then his sister, Gianna Spataulos, is his.
What's her name? What's her name?
Gianna Spataulos. That's his co-sister with one father, two mother size, some kind of relationship. That his co-sister sits in the office. She runs that entire administration, and he sits in the same office. They run the entire show. And then they have the employees are there. Everybody coming using the 806 Capital email, the correspondence with all of us with the same email. And then what he did it is, once the water got leaked, I asked for relocation. First of all, where I need to live. First of all, he didn't let me go anywhere. He said that he had to live there. Whatever, enter my bedroom is leaked, or living room is leaked, my bathroom is leaked, and then they are trying to, we're trying to dry that walls. And then there is no way that we can live in that house, so we need to relocate somewhere else. He did not arrange any relocation. So on my own, I've hired a hotel. I moved on to the hotel. And then he has a dispute with.
Interrupt again, plaintiff. Understand that I've read your submissions. I'm trying to understand how, assuming what you say factually is true, how in fact there is legal redress for what you say occurred. So that I think I understand what you're saying as it relates to counts 26 and 27. I now want to move to the counts 28, 29, and 30.
Even in the bad faith, and one more wrinkle is there, in your honor. He wrote, when the dispute is happening, and when I'm trying to argue with him with these disputes with the relocation expenses and the reimbursement of expenses, suddenly there is a dispute came with my neighbors. Then he used them as an instrument to take his revenge against me, and then he incited them to file police complaints after I sued my neighbors. On January 20th, I sued them. On January 20, between 20th and 24th, there is so many emails were generated. They all discussed together. And then the best defense is the offense. That is a strategy they took it. And then instead of defending their own lawsuit, they all come up with an idea that file police complaints until police lock me up. And that as soon as that final email comes in, within 2 hours, police complaints started. Relentless. I'm not even there at my house 9 out of 10 times. There is a security camera was there, I was not there. Police coming and going, and I've been asking police, look at the security camera. Why don't you insist? Why don't you take action for these false complaints? They did not done nothing. But this incitement is in itself is a bad faith. He should not have done inciting the people to file police complaints. And then on top of it, he used the condominium maintenance persons to snoop and shadow me in the condominium, outside the condominium, that under his own control of these employees. I've been asking them why they're following. He denies all along. Nobody's following you. You are mentally retarded. Go and then get testing with this psychiatrist. No, I'm seeing them, they're following every day, standing there, and why don't you make them to stop? Nobody's following you, nobody cares about you, and then they continue to do that. These are, when he obstruct my living conditions, and then what he says is, I'm not doing anything, and then blaming me that I am a mental retarded, and then asking me to go to treatment, but they continue the same activity of following me in the neighborhood, following me inside the condominium. And
here's my question, plaintiff. assuming factually all that occurred, your opponent, the defendant's attorneys, have said that none of that really matters in the context of the law because you were convicted of stalking and you are prevented from relitigating the question of whether or not that was appropriately the result to be had in the criminal proceeding.
Your Honor, collateral estoppel could be applied when
Sorry, say that again, sir.
collateral estoppel could be applied when I have a full opportunity to defend the allegations. At the trial, my attorney backstabbed or at worst he colluded or at worst he backstabbed me.
Sorry, say that
by-
again, sir. Sir, say that again.
He colluded or at the best he backstabbed me by not bringing the security camera evidence that establishes that at no time I have engaged in any bad activity against the neighbors. To begin with, the camera was there in place. I know how powerful the word of a white able-bodied woman's voice or word will be taken by the police or the courts. So that's why I have my family installed a security camera for me to prove, to have a, as a witness, stand as a witness for me that I'm not doing anything to them. I'm just completely avoiding them. But he did not bring that evidence to the court. Now I've been jumping up and down to watch that video camera establishing that I have not done anything to them. And I am unable to get that evidence into the record, even at the PCRA proceedings.
Very well, very well. Those are facts, and you pled them, and they are memorialized in your response to the motion. I have set internally some time frames for this argument. Plaintiff, do you have anything else to say as it relates to the motion filed by the defendants Addimando and 806 Capital?
Yes, Your Honor, Linus Addimando's invasion of privacy and then the defamation, the emails are what he wrote, that I'm a liar. I'm not a liar. And asking them to, inciting them to his co-defendants to file police complaints and then use that, telling that I'm a liar and then file police complaints. I'm fabricating my allegations. In fact, every allegation that I wrote there, I had an audio recording device, I have a video camera, I have a body camera. Whatever I wrote, they are 100% derived from those recorded devices. And I never fabricated anything. He made me a liar and he wrote an email. And then in addition, he wrote an email telling that not only his co-defendant, entire condominium, that I am banned. If they see me in the neighborhood, call the police and then complain to the condominium association. There is no reason for this wide publicity. There is no reason for that.
I want to now move on to the next motion. That would be the motion, last four digits 0185, filed by the defendants counsel for Palmer and Hodgson, as well as Borotsky, is it? Counsel for that defendant?
Correct, Your Honor. Tim Fenningham, counsel for Dr. Allison Browski, Nicholas Palmer, and Elliot Hodgson.
Your motion deals with four counts of the complaint: invasion of privacy, defamation, abuse of process, civil conspiracy.
Correct, Your Honor.
Understand that I've heard the argument of your compatriot or co-defense counsel in representing other parties to this matter. I need you to understand that I've read the submission. This is oral argument to supplement or highlight anything that is definitive and otherwise controlling that I have not read by way of the submission.
Yes, Your Honor. Thank you. Well, I do join in Mr. Herbst's position on a number of matters, including the collateral estoppel matter. Your Honor, our clients, as you've read in our submission, our client's position is simply that Mr. Vurimindi has not produced a shred of credible evidence upon which a jury could rely in defense in support of his claims. His evidence is based entirely on wild speculation and conjecture. In response to our motion, he again has failed to provide any additional evidence in support of his claims. He's had every opportunity in the 11 years of this matter, including 12 amended complaints and extensive discovery, to substantiate his claims, which he has repeatedly failed to do. As Mr. Herbst said, the vast majority of Mr. Vurimindi's efforts in this civil matter have been an attempt to relitigate his criminal matter, and that has been the primary focus of his efforts against my clients. The vast majority of his efforts in this case against my clients have nothing to do with the claims that he's filed against my clients. And if Your Honor wants, for instance, if Your Honor wants, I can walk through just a few highlights from each of these counts, if Your Honor would prefer, for our position on each.
I believe it's covered in the written submissions, and because it is, I'm not inclined to have you repeat it. If there's
Okay, Your Honor.
something additional, I'll hear it.
Yes, Rob. Well, I was just going to summarize our written submission. So if Your Honor is comfortable with having read them, then I have nothing further to supplement. Just again to emphasize that Mr. Vurimindi has presented not a shred of credible evidence to support his claims. In fact, in several different instances, the allegations of evidence that he's relying on to support his claims in the civil matter are actually the same conduct for which he was convicted of stalking in the criminal matter. So that is our position, Your Honor.
Counsel, your motion seems to be bottomed on the court having to make a judgment at this juncture on the quality of the evidence that would be offered at trial. And that, if I follow your reasoning, the quality is, one, non-existent, or is it that is the evidence non-existent, or is it the quality of the evidence you're asking the court to determine at this juncture? Motion for summary judgment.
Your Honor, the evidence in our position is the evidence is non-existent. We served Mr. Vurimindi with interrogatories asking him to present any and all evidence he intends to use to support his claims. He did not respond to those interrogatories. Repeatedly in his deposition testimony, he admitted, and this is cited extensively throughout our motion and brief, he conceded that he didn't have any actual evidence beyond speculation and conjecture in support of his claims. So our position is that he has not presented a shred of evidence in support of his claims against my three clients.
Very well. Mr. Vurimindi, I asked you to respond to that and to not revisit with me the underlying facts. Trust that I understand what you say occurred.
Your Honor, number one, I responded to the interrogatories. I responded to the request for admissions sent by the defense counsel. I submitted available facts, and I submitted the available camera evidence to this court. And also I submitted the available camera evidence through the G drive to the counsels. That's the evidence part, what allegations they did, false allegations, to prove the falsity of those allegations. The video evidence, I give it to the counsels and I give it to the court. And also I responded to the interrogatories fully and completely. That's number one. Number two, the abuse of process claim is based upon the premises that Alison Borowski bringing the criminal charges against me after I won first criminal complaint in the municipal court. She brought me, she filed a private criminal complaint, and then harassment and stalking charges were filed against me. And then I asked for a trial. She asked for a binding arbitration. And then we both went to that. Finally, I was compelled, forced to get into the binding arbitration.
Say that again, sir. Say that again.
I was forced to get into the binding arbitration. And at the binding arbitration, I explained my position, and then she explained her position with the current judge. His name is Diane Gray. He was her counsel at the time. He explained her position, and he herself also explained her position. At the end of the arbitration, the arbitrator, Eileen Flood, determined that I have not done anything with an intent to annoy, harass, or cause emotional distress or bodily injury, and then dismiss those stalking and harassment charges. And then I asked her that I cannot trust this lady. She brought me criminal charges. I cannot live with this lady, neighbor, without my camera evidence, without my security camera. Then at that hearing, Alson Borowski agreed for the continuation of the security camera, and then the arbitrator allowed me to continue the security camera. And then at the time, on the arbitration date, I already filed a writ of summons to sue Alson Borowski for bringing these criminal charges and defamation and then other ancillary claims. And I also told the arbitrator, this is what I am filed. And then at the time, she told that I cannot stop you to withdraw the civil complaint. You go, you have right to sue them. And then she has right to defend. She can defend herself. Then we come out of the arbitration. There is a mutual stay away order between me and her. She cannot do anything to me, and then I cannot do anything to her. But after I come back, and then the entire condominium, all these her co-defendants joined with her and asking me to get out of the condominium, move out of the condominium. And then to please them, I filed a motion to withdraw the lawsuit in this court, but they were not satisfied. They're asking me to move out of the condominium. I was at the time, I did not have a stable employment and stable income to sell and buy a new place. I continued there. And then to stop this harassment, to stave off them, then I filed this current lawsuit.
Understood. Mr. Vurimindi, question for you. Who other than you and your testimony would be offered to substantiate any of the factual claims you're making?
Documentary evidence of the abuse of process, emails, and then the video evidence of falsifying my bad conduct.
The question is, what persons would be testifying at trial on any one of the counts 1, 2, 3, and 4, other than yourself?
The video evidence, Your Honor, it establishes that the scheme of bringing these criminal charges were a conspiracy to make me to withdraw the civil complaint. And then once I refuse, they bring these criminal charges against me. Everything is documented. And then they made an agreement to withdraw these criminal charges if I sell this condo and then move away. After I agreed to sell this condo and move away, but for filing opposition to preliminary objections in this case, they went back to the Commonwealth and reneged that agreement and then bring back.
Wait, they went back to, I'm sorry, sir, they went back to the Commonwealth and what?
And reneged the agreement to nolle prosecute the criminal charges and then brought additional criminal charges. This is all documentary evidence, Your Honor. There is nobody need to testify for these claims. But whereas for the defamation and invasion of privacy, it's my testimony, Your Honor. I'm going to testify what I saw with my own eyes, what I recorded, what happened surrounding me. And then I have not allowed to take depositions at the time. They went to the court and bring the criminal violation of the stay away order for asking the evidence.
Say it again, please.
They file a complaint for violation of stay away order for serving the subpoenas and then asking for the discovery. They even take me to the criminal court. They prosecuted me for asking favorable evidence and witnesses among the condominium. They stopped me in my tracks, even to take the favorable affidavits or the testimony or take their addresses. Right now, whoever is involved in that in the transactions, many of them are not living there anymore. So I am unable to get in touch with them. Otherwise, I will call the Starbucks workers who worked there. Otherwise, I would like to call witnesses from the Charlie's Place. I would like to call the Gianna Spatolas. I would like to call the Leonard Addimando himself, who write these emails and inciting them, and then these watchmen and everybody. And then bring them to the court and then run this video evidence and then show to the jury what they have done, what actually occurred.
Thank you. I'm now moving to the motion filed under last four digits, 0378, by the defendant's counsel for Jason Tiefenbach, is it?
Good morning, Your Honor. It's Jason Tiefenbach. Your Honor, I will stand on the written submissions that I've submitted on Mr. Tiefenbach's behalf, and I also join in the arguments made by counsel because most of the counts have already been addressed by Mr. Herbst and Mr. Fenningham. Or should I say all of the counts against my client have been addressed.
And Your Honor, this is Dina Young. I'm a defendant in this case. I didn't enter my appearance yet, but I would like to do that. I'd like to join in these motions for Jason Tiefenbach and the other defendants for the same reasons that the other defendants raised. There's absolutely no evidence brought into this case against me whatsoever. Never has been, never will. I don't even know if this motion would be opposed.
So you are pro se, Ms. Young?
Yes, Your Honor.
How did you receive notice of this hearing?
I received, I don't even know how I received notice. I think maybe ECF notification, but I, for some reason, was unaware of the June 6th deadline to file a motion.
Very well. Plaintiff, is it correct, based on what I've read, that your case against this defendant relates entirely to allegations of the surveillance conducted on you? Is that correct?
She was the, what you call a condominium executive committee member. And then that's how I knew condominium association executive committee member. That's how I knew her. That's how she got involved in this case. And she, yes, Your Honor, she conducted the surveillance against me in that neighborhood, in that building, along with the condominium maintenance persons. And also there are some weird threats were being also issued. There were some comments I made in that my complaint. And then her boyfriend at the time, right now husband, he also threatened me at the time. And it is her assistance, her encouragement to my neighbors to file police complaints. She was working in the Defenders Association office. She has some knowledge about the criminal process. And then the Alison Borowski was her friend, not friend, she was communicating with her. And that her role is encouraging, even Rajani Pattinson was her
Sorry, say that again, what name?
Rajani Pattinson was her, I don't know, friend or acquaintance. And they both were filing police complaints to me. Is the one Addimando's email, and then Addimando's email was being returned in talking to the DNA.
I'm sorry, say that again, was being returned?
Has been generated after talking to the DNA. Leonard Addimando wrote that email to file the police complaints against me, was written after he conferred, he talked to the Miss DNA. And her involvement in this case is to, after filing the civil complaint, escalating this level of crime, where there is none occurred. None of the alleged conduct after arbitration never occurred. It's all fictitious, completely fictitious.
Very well. And you would say the same thing about defendant Jason Tiefenbach?
Jason Tiefenbach, he even tried to trap me into the criminal conduct by standing there and then trying to lure me into the conduct after issuing the mutual statement. It's not just surveillance. It is the covert activity to lure me into committing a crime by making me to go and talk to Alison Borowski. That's even dangerous defendant among all of them. He is acting like as if he's my friend and then luring me into the criminal activity in conjunction with the Alison Borowski.
Very well.
Not only just staying there at the condo entrance and then following me and then telling me where I am.
Guys, I'm sorry, sir. Say that again. Start over.
Telling me where I am in the condo, where on the streets to the Borowski. Other than that, he lured me into trying to trap me into committing a violation of the stay away order.
Very well. We're now at what is the last motion filed, that being by counsel for defendant Daniel Siegel, last four digits of the motion 1511.
Yes, Your Honor. Once again, Mark Brownstein for defendant Daniel Siegel. I can only echo and not to belabor the oral arguments that have been presented in front of you, but I can only echo the same sentiment that had been voiced by defense counsel. We have 4 surviving claims after, I believe, 10 series of amended complaints. 28, 29, 30, 31, defamation, invasion of privacy, intentional infliction of emotional distress, and conspiracy.
Let me interrupt you, counsel, and ask this.
Sure.
Are there any cross claims? And if so, by whom? Your proposed order threw that question or brought that question to mind. Are there cross claims?
Your Honor, I don't have it in front of me. I thought early on, and it's quite possible one of the complaints that had been dismissed, I may have filed cross claims, but frankly, I don't think there are any surviving cross claims at this point.
Very well. I interrupted you. You may complete.
No, I apologize for that. Your Honor, if you had a chance to take a look at our motion, there are a series of references to the deposition that was taken of plaintiff on May 3, 2022. And there are several responses by the plaintiff that my client may have been coincidentally following him on their way to the sweat gym, which was literally 100 feet from in front of the condominium where both my client and the plaintiff resided. They typically would walk over after work between 5:30 and 6. And this is the gist of plaintiff's surviving counts against my client, that he harassed them, that my client followed Mr. Vurimindi too closely. And when I reached the point where I asked him what evidence did he have with respect to invasion of privacy and intentional infliction of emotional distress, he admitted that he could be wrong. And that's attached to our motion for summary judgment. With respect to the civil conspiracy and the defamation, the 7-pronged test of defamation, it just doesn't pass. This is the most vexatious, non-meritorious series of complaints I've ever seen in 43 years of practicing law. So with all that, Your Honor, I would ask that defendant Siegel's motion for summary judgment be granted.
Plaintiff, any response?
Your Honor, I have sued 10 condominium residents. In that condo, there are 40 of them are there. I mostly interact with all of them. And
Say
I
that
did
again,
not,
sir. I'm sorry. Say that again.
I mostly interact with all of them at some point in time, but I never sued remaining 30 of them. These 10 people were named in that complaint is because of their overt acts of making my life miserable in the neighborhood. And in the criminal trial, there is no evidence against me other than my neighbors, whatever they want to testify. That's all they have. That's the evidence against me, is that what they testified, what they saw, what they testified. And then here, with these activities, whoever these defendants are doing in the neighborhood is what I saw with my own eyes. And I'm entitled to tell what I observed to the jury, what I saw, and let the jury decide whether they want to believe that white woman, white men testimony or my testimony. In the criminal trial, the judge believed whatever they testified, all the lies, she believed and she convicted me. And at the civil trial, and the same, my evidence, my testimony, my observations should be presented to the jury. And this defendant, he not just simply followed, he put me in a bad light in the gym, in the neighborhood. He used to work for these restaurants as a vendor or something. Somehow he knew these restaurant workers. And then he put me in a bad light with those restaurant workers. And also he put me in a bad light with the trainers in the gym. And then I have to stop going to the gym because of this dude putting me in a false light about what I am intended to do, what I'm doing when I'm coming to the gym. When I need the gym activity, when I'm suffering from depression, when I most needed it, I have to stop going it. It's not only that one, all these defendants combinedly, they didn't even let me have a dog to let me, giving me some kind of moral support and walk in the neighborhood. They didn't let me to do it. They followed me through the neighborhood and telling to other dog owners, don't talk to me. I never seen, I have been living in this country for good 15 years before this criminal case coming in. And then I have hundreds of relatives here coming from India. None ever told this kind of a ganging up against the entire white majority condominium association against one minority person because of his religious beliefs or his opposition to the late night parties, or maybe
To what parties?
late night parties in the condominium, or some kind of frowning about the general what is going on in the society when it did not meet past his religious test. And solely for that reason, they ganged up me against at the condominium and trying to move me out of the condominium. They brought these criminal charges, and then they brought the criminal charges to blackmail me to withdraw this civil complaint. And there is evidence that Alsan Borowski sent me a agreement that I had to withdraw not only complaints against her and against all the defendants, then she's going to withdraw her counterclaims against me. This establishes the entire whole the criminal charges and these allegations and the ganging up against me is to defend in this civil suit. They could have done simply by telling, hey, there is no evidence. They could have fought in the civil case, but the best offense is the defense strategy. They overkilled, not only send me to the prison, They come to my immigration court and testified in the immigration court. And ultimately, what happened after 6 years of that detention? So third circuit court 3-0 thrown out of
Sorry,
the
say that again,
immigration.
sir. Sorry, say that again.
Circuit court thrown out of the deportation order 3-0. There is not a single dissent in that one. Since the beginning, they have been using these public protection processes to destroy me, to blackmail me, or to compel me to do something what they want me to do. There is no reason for these witnesses come to immigration court and testify falsely against me and getting a deportation order.
Well,
Criminal case is one thing.
at this point, I am loath to continue the hearing. We are here on what has been filed as an action in this jurisdiction. I have no interest in piercing into what may have happened after the filing of this lawsuit. And for that reason, and for the reason that we've been at about an hour, and I found this argument instructive and am prepared now to end it. Is there anything else from any of the moving parties?
Yes, Your Honor. I would like to point out that the email from Mr. Addimando that has been discussed is Exhibit C to plaintiff's complaint.
So noted. Anyone else?
No, Your Honor. Thank
No,
you.
Your Honor.
All right. With that, the hearing is now concluded. I thank you all. Have a good rest of the day.
Thank you, Your Honor.
Thank
Thank
you.
you, Your Honor.
Have a nice weekend, everyone.